Hi guys, it's Kathy. I hope you're doing well. I hope you had a good night last night. I had a good night last night. So I closed last night. It was my first shift of a real show. Um, since we opened back up, we were down for 8 weeks for renovations and everything. So I haven't worked a shift in 8 weeks. So last week or before, I did do 2 shifts of training. I hate training shifts. Look, guys, I really hate training shifts. I really, really do. We had 2 shifts of training, which were torture, absolute torture, from the second we started to the end. And then last night was the first show. Well, it was sold out, and me and another girl were the only 2 servers that have ever been there before. Everybody else was brand new. So it was a fantastic night. We did. It was crazy. It was bad. It was a total shit show, but it was such a good night. But 2 nights ago, I fell down the stairs. Right? I didn't fall down the stairs. I have this cat. Cat. Lafayette. And he is buff. He is extremely muscular. You can see his muscles chiseled through his fur. All right? He'll jump from one side of the room to the other side of the room. When he wants to go somewhere, he doesn't just walk. He jumps from one side of the room to the other side of the room. You'll just be sitting there minding your own business, and there's a cat flying through the air. So he's often on the first step, and I often tell him he can't be there. But he doesn't listen to me. So I was walking down the stairs, hit that first step, and I stepped right on this cat. I don't feel bad. I'm not saying sorry. No, there's zero guilt here. Zero. Well, I didn't. He's solid muscle. So he turned and pushed my foot off of him. And my foot went down, and then I went down. So I did my live stream yesterday, and I felt some tenderness, but it was fine, right? Today it's way worse. It's not even funny. So I got home from work last night, and I started this 3-hour trial. I'm like, I am not going to have these guys sit through a 3-hour trial. I'm going to put the whole trial up in members only, unedited, which I got that done. That's done and saved and ready to upload. And I said, I am going to go through the rest of this trial. I'm just going to pull out opening statements, any testimony that's good, which there is a body cam and everything. So closing statements, and then done. No police officers unless they say something crazy. So I did the members only first, and then I was sitting here listening to the trial to cut everything, and I fell asleep sitting in this torture device. And where I landed on those stairs is killing me right now. I think I need to go get some ice. The cat was fine, by the way. So don't ask me if the cat is okay, because he's fine. Just barely. He's rolled me right off them like I was nothing. From now on, I'm going to approach the stairs with a water bottle fully spraying. A Nerf gun fully spraying. If he happens to be sitting there, he's getting soaked. Then I can walk down the steps and probably slip and fall, even though it's carpet, because the steps are wet. That freaking cat. Oh, I'm so mad at him, though. He's been giving me a lot of space since then, which is a good thing, because he made me fall down the steps. He's trying to kill me. Anyway, we're going to do a protection order. I need a protection order from my cat. Okay, wait. I see YouTube chat on my screen, but I don't see it moving over here. It's moving right there a lot. It's not moving right there a lot. Maybe it has to catch up. Maybe it does that every morning. I just don't even notice. There it goes.
And Shirley Stevens and Samantha Dennison.
No.
So, Tabitha Gillen, if you can come on up here and have a seat.
This isn't the audio that I heard when I was getting this ready. Hold on.
And then,
like it won't ring. It'll
Yeah,
just go straight to voicemail, even though I'm not being
We're
blocked.
not watching this. I'll
And
fix it.
it's
I don't know why
me and
the
her.
audio
I've
is so
proven
bad.
to her multiple times when we were having issues that like I could pick my phone up and try to call
I
her,
don't get
and
it.
it won't ring
This
through.
is what I
but then
hear.
you
If
call
I
it
would have
from a
heard
private
this
number,
while I was
it'll
getting
go
this
through.
video together, I
Or
would have.
sometimes you got to call a couple of times back to back. But as far as the
See
level
if
of
I have another
harassment or
protection
like
order
a threatening
ready,
man or any of that,
so that I don't have
it's
to change
definitely
my
not
title
accurate
and
in my
thumbnail.
opinion. I've also went as
I think
far
I might.
as setting up through school for the bus to be, for the kids to ride the bus to get picked up and dropped off at my actual house.
Yeah, I got one.
So that way we have to limit,
I got a
to limit
protection
our
order.
interactions with each other as a.
The parties waive a pre-sentence. Right. So
Okay, this may not be a protection order, but there is a protection order put in place. So, my title's not a complete lie. Hi, Clarice.
I take it we have victims for this case?
Yes, you got it.
Thank you, Ms. Ray. All right. So are we ready to proceed then with sentencing today? Yes, sir. Okay. And Sarah, you're ready to proceed?
Yes, you got it.
All right. And what we'll do is we'll hear from witnesses first, and then we'll hear from defense counsel, and then we'll hear from the state, and then Ms. McDaniel, if there's anything you feel needs to be said at that point, you'll have the option, okay?
Yes, sir.
Okay. So let's hear from the victim, please.
Yes, Your Honor, to call Don Wilkins.
Morning, ma'am. Before you sit down, I'm going to ask you, you promise to tell the truth, the whole truth, and nothing but the truth, so if you got very good. State, will you please introduce your witness?
Now, why don't you tell the judge your name?
my name is Dawn Wilkins, Your Honor.
Thank you, ma'am.
Do you have a statement that you would like to read to court?
Yes, I do.
Please go ahead.
Good morning, Your Honor. I struggled for weeks deciding whether I should speak today. At first, I planned to submit a written statement because I am afraid of Tracy McDaniel. The truth is, I will likely always carry some fear of her. For a long time, I convinced myself that what I had to say did not matter, that my voice was not important. Somewhere along the way, the truth became distorted and I lost my strength and my power. I am here today to take that back. It is important to me that Tracy hears directly from me. This will be the last time I address her. I moved into my home in 2005 as a single mother with a 5-year-old daughter. It was my first home. I worked hard to create a safe, stable environment for my child. I am a nurse of 21 years. I have built my life around care, professionalism, and service to others. My home was meant to be my sanctuary. Over time, I developed what I believed was a friendship with Tracy McDaniel. I trusted her. During a vulnerable time in my life, after a relationship ended and my daughter left for college, I confided in her. I believed she was someone safe. When that relationship deteriorated, her behavior shifted into harassment. I received hateful and threatening messages. False information was spread about me. When I attempted to defend myself with the truth, I was mocked, blamed, and called attention-seeking. The harassment escalated. Tracy yelled threats at me from her yard, that she would beat me, that she would have someone drag me into her yard, that she did not care if she went to jail. Police were called on multiple occasions. I recorded incidents because I was afraid and needed documentation. I altered my entire way of living. I stopped using my backyard. I changed my work schedule to avoid being outside when she was home. I installed cameras. I placed privacy film on my windows facing her home. I limited visitors to my home. I stopped attending a church I cared about because she told me not to return. I let parts of my property go unattended because I did not feel safe maintaining them. I became hypervigilant in the one place I have felt secure, my own home. On June 23rd, 2025, at approximately 7:30 in the morning, I was watering flowers in my front yard. Without provocation, Tracy began yelling insults at me. When she advanced toward me aggressively, crossed onto my property, I reacted defensively by spraying my garden hose in her direction. She then grabbed me by my necklace and clothing, pulled me down from the step where I was standing, and physically assaulted me. She punched me, she kicked me, she pulled my hair. We fought on the ground until I was able to get free. As a result of that assault, my toe was broken. I missed a full week of work. I spent 8 weeks in a walking boot. I had to work in that boot. I had to drive in that boot. I had to mow my lawn in that boot. I went on a planned birthday trip because I was unable to participate in several activities because of my injury. Every step was painful. Every day was a reminder of what had happened. The physical injury healed, the psychological impact has not. I am a survivor of prior domestic violence. It took me years of therapy and personal work to rebuild my sense of self and stability. This incident reopened trauma I had fought hard to overcome. I returned to therapy immediately and continue to regularly attend. To this day, I do not feel safe in my own home. I live next door to the person who assaulted me. Every sound, every movement from that property keeps me on alert. That is not peace. That is not freedom. That is not how anyone should live. Tracy, you were never a good friend to me. A good friend does not intimidate, threaten, harass, and assault someone. A good friend does not attempt to erode another person's sense of safety over years. You did not destroy me, but you did harm me. I am here today with clarity and strength. I was the victim of ongoing harassment and a physical assault. I did not imagine it. I did not provoke it. I endured it. After today, I move forward as a survivor. I ask the court to consider not only the physical injury from June 23rd, but the years of intimidation, fear, and emotional harm that led to that moment. My home was supposed to be my refuge. Instead, it became a place of vigilance and anxiety. Your Honor, I am asking for full accountability. Thank you.
Thank you, ma'am.
Thank you for sharing your statement. When the judge is considering what sentence to issue, what does accountability look like for you?
I thought about this a lot, Your Honor. And I don't know what the possibilities are for punishment for this crime. What I do know is that what I would like to see happen is Tracy McDaniel is evaluated for mental health disorders. I would like for my protection order to be a lifetime protection order if possible for stalking. I would like to see Tracy serve some type of community service, probation, and even jail time if possible. I feel that she deserves whatever punishment you offer to her. And I hope this can be resolved today. and I never have to speak on her name again.
Maybe further state
Nothing further than state.
defense?
No, Your Honor.
Thank you, ma'am. We have, the rest of the hearing will go as follows. We'll hear from counsel, we'll hear from the state, then you'll have that opportunity to speak if you'd like. Mr. Newman.
Thank you, Billy. Tracy is 59 years old. She does have one son who is 60. Oh, I apologize. She's 60 years old. She has a 42-year-old son. She has 3 grandchildren, ages 10, 16, and 22. She's been married for 26 years. She has no criminal history whatsoever. Her life, I think this is my summary of how she's described it, is essentially
Hi, VFA.
family, work, church, gardening, and dogs, and maybe not in that order necessarily. She attends Faith Apostolic Church every Sunday. She goes to retreats. She helps volunteer and do things at the church. She works right now at Chick-fil-A. She's been there approximately 1 year. Before that, she had been at Holy Cross for 15 years, as well as running a kitchen for a Marriott hotel. She does have some health issues, peripheral artery disease, a blockage, I believe, in her legs that will be requiring some upcoming surgery to potentially put some stents in her legs. In terms of the situation with her neighbor, I rarely, if ever, and I don't really want to go down the path of maybe a provocation or something like that. You know, I think this is probably a buildup over a number of years, is truly what it was. Some racial slurs being put out there, and I don't want that to be the focus of anything. This particular day, my client had pulled up at her house, and it was a day of a funeral for kind of a local kid that a lot of people here know named Jerome Cornell. So it was just, I think, maybe that boiling point or perfect storm at this particular day. But again, I don't want that to be the focus. I prefer the focus, obviously, to be on her, 60 years of a law-abiding life and doing good things in the community and for her family. In terms of them being neighbors, they're still neighbors. Something Tracy asked me to do when Shannon Guari, some attorneys from Anderson, Augustino, and Keller filed a protective order. My client consented to it immediately. We met, we resolved that with Judge Donnelly, Magistrate Donnelly. So there's been no interference in terms of these protections that have been put in place already. I want to say that protective order was put in place in August or thereabouts. There have been no issues since. Both homes are loaded up with cameras and things like that. There's just been no issues since then. Secondly, my client was sued civilly through the small claims court here in St. Joe County. I wasn't aware of it. She told me kind of after the fact that she went there and she settled that claim and in the amount of $7,500 restitution to Ms. Wilkins. So she's she's holding herself accountable. That way she's already paid $1,000 and I think $100 per month is the payment plan on that particular case. Your Honor, I mean, this is someone who will respond affirmatively to probation. I'm asking for the court to impose probation. The agreement of the parties is that there's an immediate treatment as a misdemeanor, and that as a term of any probationary sentence, she would have to have that mental health and substance abuse assessment. I suspect that there won't be, just spending a lot of time, probably more time with Tracy than I have with many clients. I suspect it's going to come back that she doesn't have those issues, but she's more than willing to respond to anything the court puts forth. Thank you.
Thank you, Mr. Newman. State.
Yes, Your Honor, as we heard from the victim, this was not just one singular incident. This was a period of harassment, and it appears that there were issues that kind of extended for a longer period of time. There was an injury in this case. The reason that the plea did not incorporate restitution is because that had been dealt with separately. I think one of the great things about living here is that you get the ability to be safe in your own home, to use your backyard, your front yard as you please. And it appears that Ms. Wilkins did not have that opportunity because of Ms. McDaniel. So the state's request is to sentence Ms. McDaniel to a probationary sentence, that mental health and substance abuse be a required term of that sentence, and that Ms. McDaniel serve 100 hours community service. That should keep her busy and not interfering with her neighbors.
Thank you, State. Ms. McDaniel, anything you want to say, ma'am?
No, sir.
Yes. So when I look at whether or not to accept an agreement like this, I look at what the end goal of the court is, and the end goal is different depending on different individuals. You've seen some individuals this morning who have used up the grace that the court can sometimes offer to people.
Linus, we should pick somewhere in the world where we should both move there and each become lawyers on opposite teams. And then every day we can go to work and just argue with each other every single day.
And have failed to take advantage of the opportunities that sometimes the court offers to people. And you've seen what it looks like when punishment becomes what we have left to us. So you've seen that today. The agreement in this case calls for you to plead guilty to the cause, and then for the court to sentence you as a Class A misdemeanor, which carries possible punishment of up to a year in jail and fines up to $5,000. It's almost never happens that somebody with no criminal history whatsoever in 60 years of law-abiding life and employment, family, goes to jail on the first offense of a misdemeanor nature, even if there is some violence involved, and there is some violence involved in this case, which is troubling to the court, because for a couple of different reasons. One is that there's a victim out there in the community. Two is that it represents such a substantial departure from your other 60 part of your years. You know, it's a big break. It's not a small glitch in your armor or whatever. You know, it's a pretty substantial departure from who you've been and what you've been up to this point. So that causes concern. And that's, I think, the victim pointed out, the state pointed out, it's embedded as part of the agreement that you got to do a mental health and substance abuse assessment and follow through with any recommended treatment. If Mr. Newman's right and there's no issues there, that's almost more puzzling to the court. If there's an issue, it's like, oh, here's what happened. We can work on this. If there's no issue demonstrated, then it was a lapse of self-control that is unprecedented in your history. And that's, I mean, we don't know what to do about that. We don't quite know where to put that in a category or in a box. You know, it's one of those anomalies. We hope it's an anomaly and not the start of a new trend. It just bucks your other 60 years of demonstrated law-abiding nature. So we're accepting the agreement, and the no contact order in this case will continue throughout the sentence. You have a protective order issue in another court, so that's still out there too. So we're kind of just doubling up on that. You get. I don't know that incarceration at this time is appropriate. If we come back on violations and things of that nature, including violations of the no contact order, then certainly all that's on the table. I don't have to lecture you. You're a 60-year-old lady that understands the way the world works. You've seen more of court than you ever wanted to see by having been here for your several hearings. And I think you understand that it would be foolish to mistake the court being courteous or kind with being weak and effective. I think that's not a mistake that you're likely to make. So I think that on balance, we do 12 months of supervised probation, and we see where we end up at the end of that 12 months. If there's no violations, then perhaps this is that one anomaly. And it's sad that the aftershocks, the ripples in that pond that you've created will continue to impact Ms. Wilkins, and they'll continue to impact you too. You know, the ripples don't just go one way. They go out from the center and they hit everybody. So that's what the sentence will be, is 12 months of probation with mental health and substance abuse assessment, followed through with the recommended treatments. The no contact order, no order that you not possess any firearms during the term of your probation. And there will be $100 probation fees up front, and then $15 a month, and $189 of court costs. Was there a bond that was posted? Or did we OR in this case?
It was with OR.
Okay, so those fees will be due and owing during the term of your probation. I have probation rules for you here. Of course, you've not been on probation before, so you don't really understand this maybe, perhaps you do. But when you're placed on probation for 12 months, if you serve 7 months and then violate, you're exposed to 12 months of incarceration. That's what could happen to you. So, do we have any days of credit in this case?
You can turn yourself in.
Yeah, I'm
So I think 1 year.
1 day? So you'd be entitled to 1 day of Class A credit, but you'll have that entire 12 months of probation right up until, if even after that probation term expires, you could still be subject to.
It's Judge O'Donnell. I think I would rather be the prosecutor, but I can be either. But I think I can show just moral outrage at shoplifting or any of his crimes, but we're going with shoplifting. And I will be so outraged by this crime of shoplifting that Monica would be ready to put him in jail for life. Now Linus will have to show compassion and list all of Bobby's good traits to try to change my moral outrage. It'll be great.
Revocation within a period of time after that, if there's any violations. So you understand that the stakes are very high for you. And I think you want to get back to being the lady that you were for 60 years, minus this 1 day. And I think your neighbor would really like you to be that person also, because that person, and here's the other thing that we have to address, is both sides mentioned a build-up to this. I don't understand it. I'm an outsider to your relationship. I don't have to understand it, but I do know this: there has to be peace on these little properties that are a microcosm of the rest of our world. There has to be peace, there has to be comfort, there has to be some security.
Can I say something, Your Honor?
Well, I don't know that it would be a good idea at this point.
Okay.
Thank you. And, you know, if counsel said that perhaps there was static flowing both ways, I don't know, and I kind of don't care. I just know that here's the point at which we have to stop and start fresh.
Yes.
And, you know, probation is grace. The court's extending some grace. I hope that perhaps we can extend grace to each other on an interpersonal level. And grace and trust are not the same. I expect that if there's to be any trust, that will be something that we won slowly and over time. But I would hope that we can, by faith, extend grace on the front end and see and hope that that carries us through. So we're looking for a fresh start here, and really be able to do what you want to do on your property, not encroach on your neighbor, not interact with your neighbor in any way, which is weird and odd and a little bit artificial, but it's what we have to do at this point. I've told other people, I can tell you too, that you hold the keys to the jailhouse in your hand. There's a lot riding on this for somebody who has no priors. I have here the rules of probation. Go over those with your attorney, sign those if you understand them and agree to be bound by them, because you will be bound by them as soon as you sign them. When you leave here today, you'll go out and meet with the probation department and establish a relationship with them that will continue over these next 12 months. This is one of those cases where the level of the offense maybe doesn't match up with the level of the impact, the amplitude of the waves, the ripples that was created. And I understand that the law is not a panacea. It doesn't fix everything for everybody all the time. It's really a crude implement that kind of hews the outliers smooths it out the rough places just a little bit in order to find peace and true justice in our communities. It takes a lot of work on an interpersonal level, and I hope that we can get there together. And if not, then we go back to that crude implement. It starts to look a lot more like a cudgel than a gavel, but that's what we have to us. Any questions?
No, Your Honor. I don't know if you have other business from when the last kind of person here. Did you want me to review it here?
That's fine. Go ahead, take your time. Anything further state?
Oh, yeah.
Ms. Wilkins, you are heard today. I hope you feel that.
I love that last part. Miss Wilkins, you were heard today. All right, let's go to this one.
You failed to maintain employment.
Yes.
Also, at some point in time, did you fall behind in your probation fees?
Yes.
Did you also fail a drug screen for THC on June 10th, 2025?
Yes.
Did you also fail another drug screen or admitted to the use of marijuana on you admitted to it on June 26, 2025, that you had used on June 25th of 2025?
Yes.
Did you also fail to report at least once while you were on probation?
Yes.
And did you further admit to using illegal substances, methamphetamine and marijuana on July 24th, 2025, and that would have been admitted on June 25th? I apologize, July 25th, 2025. Meaning, did you admit to your probation officer that you had used methamphetamine or marijuana the day before?
Yes.
And were you unsuccessfully discharged from the Marshall County Drug and Alcohol Program?
Yes.
And did you engage in criminal conduct where you at least were convicted of one of the charges? I'm not saying necessarily both of them, but at least one of the charges under 20H012512CM9538?
Yes.
And that was while you were on probation, correct?
Yes.
And here's where we get to the third amended. Well, I should say that new criminal charge is from the third amended, third motion to revoke your probation. But also, did you fail to report to your probation officer on September 19, 2025?
Yes.
And Mr. Ariano,
Now, I think this is the one, Granny, where she doesn't know how this is going to end, which makes this one so funny.
did Ms. Rose ultimately admit to the marijuana charge in the Elkhart City Court, or was it only the driving while suspended charge?
She pleaded guilty to the possession of marijuana charge, Your Honor.
And so the third amended, third motion to revoke your probation says that you purchased, possessed, and or consumed an illegal substance, marijuana, as it relates to that new criminal charge in the Elkhart City Court. And do you agree that you at least possessed marijuana as part of that criminal offense?
Yes.
And also, at some point in time, you were sentenced to complete 40 hours of community service as a term of your probation. And did you fail to complete that 40 hours?
Yes.
Mr. Ariano, any further questions on the factual basis?
No, Your Honor.
Mr. Langowski?
Mayor.
Ms. Rose, do you have any further statement for the court about the facts of this violation and or the sentence that the court's asked to impose?
No.
Do you understand now what it is that you did to violate your probation?
Yes.
And you ultimately agree that you did those things? That, I mean,
Yes.
no one else forced you to do that. You simply did them.
Yes.
Well, thank you. And that is essentially what I needed to go through with the admission. So I am going to find that there is a violation. I
Breno, I'm so sorry. That sucks.
am somewhat hesitant just because there were 2 years suspended here. I think given the tracking of this, how many violations there were being 3, and then the 3 amended violations would justify a longer sentence, but ultimately the parties agreed to it, so I'm going to be accepting the terms of the plea and imposing the sentence. What that means, Ms. Rose, is that I'm going to formally revoke your probation, terminate that unsuccessfully, subject to the completion of the 180 days in the Marshall County Jail. All of those days will be served, and you will receive good time credit, which effectively makes that 90 days. And, oh, now that I say that, one complicating factor is, let me back up, Ms. Rose. I failed to mention, and this does fundamentally change what you had asked and my answer, so I want to clarify for you. The 180 days is subject to good time credit. However, when I said it was day for day credit, that was a mistake. This is a level 5 felony, so you don't receive day for day credit on the jail time credit. You would only receive credit for essentially having to serve 75% of the time instead of 50% of the time. So that would increase the amount of days that you actually have to serve because it is not day for day credit on a level 5 felony. Mr. Ariano, did you go over that with her at all?
Your Honor, we did discuss the amount of time. It's been a couple of months since we signed and filed this, so I can't remember the exact details. But because of the level 5 felony, obviously, good time credit laws are what they are, 3-to-1.
Yeah. Well, I made that mistake, and that's my fault. I should caught that it was a level 5 felony as compared to a level 6 felony when I said it was day for day credit. Let me back up also for you, Ms. Rose. Understanding that it is not day for day credit, and I'm trying to look at your credit time now, but understanding that it is not day for day credit, and you'll only receive essentially 1 credit day for every 3 days you serve. And the way that works out is ultimately you serve 75% of the time as compared to 50% of the time. Does that change your willingness or wanting and desire to go forward with the plea?
So I won't go home today.
Well, I don't think under any set of circumstances it was expected that you had time served today. So that's a separate question, but I didn't think it under any circumstances it was expected that it be time served.
Well, I've been here 90 days.
Today's.
I got arrested on December 1st.
Your Honor, I show 65 days.
That is what I show as well. Now, this is a difference here. Ms. Rose indicated December 1st. The jail credit or the jail listing has December 18th. So that's likely a difference here. But you certainly received the days from December 18th. When you were saying you were arrested December 1st, was that here in Elkhart or
In Elkhart.
right here in Marshall or in Elkhart?
Elkhart.
Go ahead, Mr. Ariano.
Yeah, Your Honor. Yeah, the Elkhart County case right now. She was arrested in Elkhart County December 1st.
Well, you certainly wouldn't receive that time, Ms. Rose, toward service of this sentence. We show that you were brought here to Marshall County December 18th. Does that match with your understanding of when you came to the Marshall County Jail?
No, I thought my time started when I got arrested.
I understand what you're saying, but that's simply not correct because you're serving time in an Elkhart County case. So that doesn't go towards a probation sentence here.
Okay.
Do you remember when you were brought to Marshall County?
December 17th or 18th.
The jail has notified me that she is entitled to a little bit more credit time. They have it as December 5th, 2025. So that's actually more credit than what we anticipated. And it sounds like you were held in some other area for a period of time. So that's 78 total days. At any rate, it wasn't 90 days. And I don't think under any theory was ever going to be 90 days. I understand that you thought it was, but you wouldn't receive credit for the days that you were serving in Elkhart County towards this sentence. So,
and I didn't know that.
I understand that. But back to my question is, now knowing that it's a level 5 felony and you don't receive day for day credit, you do receive good time credit, but that good time credit classification is different because this is a level 5 felony. Are you wanting to go forward with the agreement or not?
I mean, yeah, when's going to be my out date then?
It's a fair question, and I don't typically calculate out dates. I can tell you that we will apply that credit time that I just said to you towards the sentence. That's 78 days, and then the jail time will calculate the out date for you, and they can provide it to you, but you'll get credit for all the days that the jail has you for on this case, which is 78 total days, and then you'll have a series of days left to serve.
Because I got probation in Elkhart March 25th.
I can't guarantee you'll be out by then, but certainly if you're released from the Marshall County Jail and you report immediately to Elkhart County, I'm sure you can explain that you were held in the Marshall County Jail for longer than anticipated.
And
yes, Mr. Arian.
Sorry again, Your Honor, Ms. Rose, the judge's order was that your probation is to start upon your release. So as soon as you are released from custody, you are to report to probation in Elkhart. That's what the judgment order says. I'm looking at it right now, just for your information as well.
So that confirms that when you're released from the Marshall County Jail, that's when you'll have to go to Elkhart County probation, whether that be on March 15th or a different day. I also want to be clear, if it's earlier than that, you still have to report immediately to Elkhart County. So I'm not sure where the March 15th date is, but I just want you to be clear, upon your release, report to Elkhart County probation. Any questions over the details of the credit time, Ms. Rose? I recognize that you were anticipating being released, but obviously, even if it was good time credit for day, you wouldn't be released today because I think your credit time calculation was slightly off. But any questions over that credit time discussion?
Nope.
Anything else, Mr. Ariano?
No, Your Honor. Thank you. Good luck, Ms. Rose.
Ms. Rose, I appreciate your attention this morning, and we'll get this out to the jail. And then once they have that, they will calculate the out date for you, and then they can provide that to you pretty quickly here. Thank you, ma'am. You can have a seat in the back.
I guess if you're in jail, you think that you're in jail for everything that you did wrong from every county. Like, I've been in jail for 6 years already. Well, you haven't started this yet. So I get it. I get what her thing is. Bren, that sucks because anybody born in the 80s should never say the words you said. That's just not fair. This is quick. Maybe it'll make people feel better. Oops. I pressed play on my actual computer. You guys can't see my actual computer. Thank goodness. That would be bad. My orange cat is meowing because I pet her. When she was getting a drink of water, I pet her. She only lets me pet her when she wants me to pet her. Now she's just pissed off at me and she's going to keep meowing.
Do we need the interpreter, Mr. Bustamante?
No, it's fine.
Speak English.
Yeah.
Okay.
I object to his hair.
It's great. Thank you. All right, Mr. Bustamante. It sounds like the people have a position on this case. Mr. Hershey?
Your Honor, the people would move to dismiss this case at this time. The defendant is alleged to have removed some artwork from a wall in a bar, but he brought it right back.
Yeah.
How long was it?
When I wrote the back, when they called me from the police.
Okay. So I think.
Which bar?
Back
Were you drunk?
a bit.
Yeah, well, sounds like some stupid behavior. Defendants returning to Argentina. You know, I'm reminded, Your Honor, I think it was Arnold Schwarzenegger said, when you're visiting someone's house, behave yourself. So you're a visitor just in Aspen, not that he's from another country, anyone from anywhere in the United States. I would ask that, you act appropriately here. It's unfortunate, but I don't think this case rises to the need for a deferred, which I imagine he would successfully complete anyway, since he's going back to Argentina.
Mhm.
Thank you, Your Honor.
And Mr. Bustamante, anything you wanted to note?
No.
No. Okay, it sounds like you got a, it sounds like he was lectured by both Ms. Adgate and Mr. Hershey. So,
And the police.
hey, Mr. Bustamante, we don't see you back here with any of this type of behavior.
Won't happen again.
Okay, we
Have a nice-
trust.
When are you going home?
31 of March.
Oh.
Where in Argentina?
In Paragonia, in Bariloche.
Oh,
Nice.
it's beautiful there.
Yeah, I've been. I studied abroad in Argentina.
Oh, really? Nice.
You did it?
Doesn't make it on the record a lot, but it's true. All right, thank you, Mr. Bustamante.
So you can
Good luck
keep
to
that
you.
as a souvenir, but you're done.
Okay, well, thank you.
Case dismissed.
Thank you, Isa.
Don't give him any more souvenirs, for crying out loud. Listen, people steal the wall art in the men's bathroom at the brewery I worked at all of the time. And when I say they would steal the wall art, they would actually rip it out of the wall. So there's huge holes left in the drywall. Because we would anchor that stuff down. We don't just hang it on a nail. We bury it into the wall. They are constant. They don't do it in the ladies' room, which to me is crazy because A, it's better. We have these beautiful plates on the back of the toilet in a stand, not anchored, not bolted, not nailed down. They're in this beautiful stand, and the plates look like they're embroidered. That's painted embroidery. Please remain seated. They're very pretty. They're very cute decorations. And then we have other decorations that are beautiful in the ladies' bathroom. No one ever steals those. Sometimes they make them crooked for some reason, which I don't get. It drives me crazy. But the men's bathroom, they put holes in the wall to steal the decorations. All right, next we're going to go to another really, really short one. We're going to go to Georgia for a sec. I almost pressed play on my computer. What's going on with me today? It's like I forget how to do everything.
All right, 30, that's Mr. Riles. He is in the back, so we'll come back to him. 31, Reginald Nicholas Harshaw. There was a bench warrant from last fall. Harshaw? Nothing on Harshaw.
I have not had any contact.
All right, I'll let the bench warrant will, of course, remain in place. I'll call it again before we adjourn, but otherwise there'll be dead docket. 32, Joshua D. Muse, M-U-S-E, Muse. Oh, and a co-defendant, Leslie Diane Roberson.
That's not his co-defendant.
That's not?
No.
Oh, that's an 8. No, okay, I got you. I'm sorry. I need glasses. All right, 32, Joshua Devin Muse. Yeah. All right. I'll call it again before we adjourn, otherwise there'll be a bench warrant.
Where's Wesley? Is she here?
You know, she's texting me again.
33, Leslie D. Robertson.
Your Honor, Ms. Robertson has been texting me again, and I said, this is the 4th time, I ain't doing nothing. I'm not asking for nothing.
Well, better texting you than me.
Yes, Your
Yeah,
Honor.
call me.
I'm sure she called Amy too.
Yeah. She's mad with me. I'm kind of upset too.
We've had a wrap-up, we're supposed to be resolving her cases.
For a year now.
And the last time I said, Ms. Robertson, we're gonna have a problem if you don't come next time.
Well, I don't even have to look over at Captain Solomon because I know he's going to be shaking his head. Please, Lord, no.
Is she still working at
Yes, in the jail.
She's working at the motel in Mount Vernon.
Isn't that right, Captain?
I'm upset. She's mad with me.
Well, I tell you what, Mr. McLaughlin, since you have such an easy way to make contact with her, after we get through today, we'll bring her back up. All right.
You gonna have to pick her up?
Or either the captain will have to go pay her a visit.
I'll have to search her before I bring her. And I ain't doing it.
Oh, dear God.
Yeah, Jeremy Ryan and Kelly Ryan.
I love when that judge talks to Captain. I love it. Yo, listen to what these
2511
people,
EV49.
listen to what these evil people did to this man. Seriously.
98. All right, so we have the plaintiffs here in person. Respondents have not appeared. What's your request today, Mr. Pepper?
We've got some damages, Judge. We'd like to have some testimony. It was kind of purposeful damage after you evicted them. They opened all the windows, ruined the furnace engine and or motor and not paid. So my client's got a summary. I think we filed with the court, so I'd like to have you testify.
All right, so Mr. Miller, we'll place you under oath. You can testify from there.
All right, sir.
Yep, please raise your right hand. Do you swear or affirm the testimony you give today is the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Go ahead, Mr. Capper.
Thank you very much. State your name for the record, please.
Nathan Miller.
And Mr. Miller, you have a lease with Jeremy and Kelly Ryan, I guess, that resulted in eviction this court entered. Is that correct?
Yes, sir.
And the court evicted them on or about December 26th, I guess. Is that correct?
That's correct.
And at the time of the eviction, then they were in a was it a month-to-month lease?
Correct.
And how much per month were they supposed to pay?
$860. It had initially been $800, and over the years that they were there, my dad had raised it at just as cost of things had raised on the property to $860 a month, plus utilities.
You, as the plaintiff, the actual written lease went back to 2021, but they eventually went beyond that, and that's why I said month to month. That's what it was, correct?
Yes, sir.
And that was for you and Peg, your wife, are the owners.
Yes, sir.
And so you have a summary. I think you've given to the court. Does the court have that there?
Yes.
Okay. So I kind of want to go through this, and then we'll mark it as an exhibit. But just starting out then with the month of what when they were not paying the rent?
Begin the month of August. They stopped paying totally. From the time my father passed and the property came to us, they were a month late every month, starting in January of 25. And then as of August, they didn't pay August through December at all, or their electric
The
bill.
total past due rent for damages is $4,300. Is that correct?
Yes, sir. And that's not, I didn't include any late fees. I just left it blank.
Also, and I believe you had given them notice this when you filed your complaint, but they also did not pay the utilities for the months you've designated, August or December. Is that correct?
Yes, sir.
And you had those and provided those receipts
Yes, sir.
earlier to them, and that total shows $1,696.94. Is that correct?
Yes, sir.
Would you tell the court, as you got this in order, because you got other things, would you tell the court then that what happened after the eviction was done and what they did to the house as far as the damage?
When on the 24th, I got notice that they had left the property and the doors were standing open. And so that was on the 24th. And so I contacted the sheriff's department. They came out and shut the doors for me because I wasn't wanting to approach the house at all.
What did you find then when you took over the property after December 26th?
On the 26th, we were taking the property back over at 4:00 in the afternoon. We drove through Stonecrest because we could see the property from Stonecrest just to see if they were still moving out. And we could see from Stonecrest that the doors and windows were all open. So I contacted the sheriff's department again and waited for them to get there. And then we all went up the drive together. And a deputy, Zane, what's his name? Heighton, yeah. Deputy Zane Heighton.
What did you find?
All the windows and doors were practically all the windows were open. All the doors were propped open.
What was the temperature at that time?
It was cold. I mean, I don't remember what the temperature was, but it was cold and the furnace was set on high.
What happened as a result of those actions with regard to your furnace blower motor?
It burnt the motor up. The bearings went bad in the motor. It was just running steady. They also.
And that total charge, according to your summary, was $400. Is that correct?
Say again, please. Yes, the $400 was for the motor.
So those totals, as far as your first page, then show damage of $6,396.94. Is that correct?
Yes, sir. Now they had the hot water running in all the sinks in the kitchen and the bathroom. Hot water was running steady, and it had finally kicked out the breaker on the hot water heater. So I don't know at this point. I've not included that if it was damaged or not. And strangely enough, as we came in, the doors, at each entrance door, there were like bags of golf tees had been opened up and just dumped on the floor in front of the entrances.
So in addition to that, then with those damages, then you've also provided me, I don't know if you provided the court or not, verification of the utility bills, I believe. Is that correct?
Yes, sir. The court has a complete listing from August through December from Yelp.
What else did you find when you went into the property as it relates to the condition of the carpet? What had they done?
The lease says they were not to have any animals. And they had a dog and a cat. They refused to get rid of them. I went back through my dad's phone after he passed. I started going back through the text after we got it from my mom and found that my dad had asked him to get rid of the dog. And he just makes it clear, and I've got his text there. They can be seen if you'd like, that he just let him know I'm not getting rid of the dog.
So in any event, to kind of speed up here a little bit, you have damage to the carpet that had to be replaced because of dog urine and excrement. Is that correct?
Yes, sir. Carpets were just nasty.
Did you have those estimated in terms of that total?
Yes, sir, I did. I contacted Home Depot and just asked for the cheapest carpet that they had, cheapest pad that they had, and the size, gave them the size of the rooms. And that's what it came out to.
And that is a result of the actions, inappropriate actions of the tenants. And you have that cost of $1,638. Is that correct?
Yes, sir.
Then you done a total on your last sheet. The total's the $8,000, and then you have a credit of $642. Would you explain that to the court, please?
Yes, sir. Jeremy had kept insisting that he was missing a weed eater and 2 impacts, and these are like impacts, look like a drill. I had not seen his impacts, didn't have his impacts. And the weed eater, I went back to my dad's messages, and he had done the same thing to my dad. My dad bought him a new weed eater. And so I'm sidestepping the weed eater issue, but I'm willing to take away from what they owe me 2 brand new impacts, even though we have never had them. I don't have them and don't need them.
Good. So you had those estimates, you took that credit off. So the balance in terms of damages for past due rent, utilities, damage of the furnace motor, and the carpet is $7,392.37. Is that correct?
Yes, sir.
And then also, I think you also, if you provided the court, or at least you provided to me, then the repair of the blower motor of $400 is a receipt also. Is that correct?
Yes, sir. And the court, I don't think got that in the packet that we gave the clerk, but.
Yeah, so you have the receipt there. So that's part of your damage total. Is that correct?
Yes, sir.
And I don't know, I suppose I'll mark this just for record, Your Honor.
You know that marked in
how you want to do that. But. Nobody took that and they can't do it all. Yeah. Okay, sir, I've shown everything marked as for purpose of application as exhibit A, and you've been testifying here. Is that your summary of the, of damages in.
Yes, sir. And I also included a letter to the judge and just put in just the dates that the sheriff's deputies came and responded.
Good.
And also in there that Jeremy still has tools in the garage there that he's more than welcome, always has been welcome.
Hell no, sell them on eBay. Sell them. Sell them anywhere. Have a garage sale for him. He might, though. Here's why. He didn't show up. He's not disputing anything. He's not here to dispute anything. So this guy, if he could put some evidence towards the price of something, the judge is just going to say, okay, no problem, as long as it's legal.
To get them out. But at this point, I was wanting to do it with accompanied by a deputy to be there, and I'll be there, but I'll just keep my distance from them. But he's more than welcome to get his tools.
Well, but you're saying that he can come back when he makes arrangements, right?
Correct.
You just can't come on and get him, can you?
No, sir.
Okay, so that's Exhibit A in 5 parts. Your summary, the receipt for the blower mower, the utilities, and the estimate that you got from Home Depot. Is that correct?
Yes, sir, it is.
And so we move for admission Exhibit A in 5 parts, including his summary testifying.
So A admitted?
And then you're asking the court to enter a judgment then against the defendants in that amount. Is that correct?
Yes, sir.
And you understand then you'll have to come back at a later time for any proceeding supplemental
Yes,
or to enforce that judgment. Is that correct?
Yes, sir, I do.
I think that's all we have to.
Okay, so given the testimony today and the fact that response have failed to appear, I'm going to enter judgment of $73.9237 plus court costs. That'll be all for today.
Thank you, sir.
Yeah, thank you, Judge.
Appreciate it, Your Honor.
You do that, or am I supposed to put that?
If you can put that order together.
I'll put, okay, thank you, Judge.
Thank you.
Amount of money that he will never see, ever. He'll never, ever, ever, ever get that money. Okay. I thought this next one was interesting. Some of you might find it a little boring, but I thought it was interesting. It's 12 minutes. So if you're going to make a sandwich, go make a sandwich now. But I liked it. I just did.
Mr. Stafford, good morning. I think you may have been in trial in another division when you had a colleague covering for you on Ms. Onstedt's case.
Yes.
And so today is our rescheduled trial given the mistrial that previously occurred. And I'm just looking to make sure we have a statement of the case and some jury instructions that have been filed. I see that the prosecution has given me a notebook that has exhibits in it. And have you seen those exhibits?
I have, Your Honor.
Okay. And do we have a set of jury instructions and a statement of the case?
Yes, Your Honor. And so looking at the previous filings from Mr. Cecil, the statement of the case, I certainly have a printed copy. I was under the impression he had. Yes, I think it is filed.
I still feel bad for this attorney.
September 22nd, but let me double check that that is also what I have printed. Yeah. And I can provide the court the printed copy if you give me one moment. I would also note, I think defense filed.
He has unique pipes on him, doesn't he? I don't know. I like his voice, but then I don't know what it would be like to be married to him. You know what I mean?
The Rule 24 this morning as well. May I approach the bench?
Yes. So, Mr. Stafford and the people, are you comfortable with me reading this to our panel this morning?
I had a different Rule 24 statement, Your Honor. I did file it. I would prefer the Rule 24 statement that we have because I think even last time we ran into some talk about this is involving a gun. This is involving police officers, a threat to police officers, and I think that was helpful for voir dire. So I think, those facts help navigate voir dire in a way so that they get that little bit of a preview, so that they know what kind of case they're getting into, so that we can accurately determine whether they're right for the case. So I think those facts, and I think the last two voir dires we've had has kind of borne that out, that those facts have kind of trickled in as voir dire have come in anyways, and front loading it onto the statement of the case, I think makes some sense.
So did you file a proposed statement of the case?
I did, and I can send it as well.
Just tell me what date it was filed and I can find it.
I had filed it a while ago, but I refiled it.
I think the previous statement from defense was filed September 22nd of 2025. And then in regards to jury instructions, Mr. Cecil had filed a draft on June 22nd of 25. So there are jury instructions in the file as well.
I think funeral home nailed it. But he has some comments. He has some, how he understands the law is different than what they think.
There's a WebEx window that's covering part of my screen and I can't.
Do you want me to pull up the?
Well, see, I'm trying to read this.
So
Alt tab,
just,
alt tab, alt.
And I
alt
can't
tab,
get
tab,
it low
tab, tab.
enough.
click on it and hold it and pull it down.
Oh, okay.
Just get out of your way.
All right.
I can print it for you too.
Do the people have an objection to the defense's proposed Rule 24 statement?
So Judge, I think as an initial matter, it is incomplete because the VPO isn't mentioned in defense's Rule 24. So everything that the defendant is charged with is not in their statement. I think as a secondary matter, I have not done trial in front of this court before, so I'm not sure how much the court uses sort of judicial voir dire as an opportunity to front load issues versus not.
Sure, and and I apologize. Remind me your name again.
It's okay. Caroline James, Judge.
Ms. James, you've been here many times. I should know this by now.
It's okay. It's okay.
I love that question because this matter is near and dear to my heart. Ms. Salvaggi and Mr. Stafford know that. So you've opened the door to something I was hoping to communicate with you anyway. I started my legal career in the late 1980s. And back in those days, every judge in the building would snap and wag their finger at counsel who attempted to share facts of the case with the jury panel during voir dire. Stay away from the facts of the case, counselor. It tied counsel's hands so much that it was very challenging to do jury selection. And then the jury reform movement came around and Rule 24 was modified to encourage the use of opening statements prior to voir dire so that the jury could have some context. The defense bar applauded. We now live in a world where every single trial I do, I ask, does anybody wish to have a mini opening statement prior to voir dire? If you ask, I generally grant. I actually don't think those mini opening statements are nearly as effective as a stipulated joint statement of the case, such as what Mr. Stafford is proposing. I do acknowledge that his proposed statement of the case does not mention the violation of protection order charges. So I'm wondering if we tacked what he's written onto the end of what you've written, and I just read the sum total of it.
I think that would be my request. That would work for me.
Now, Ms. Salvaggi is going to get a little smirk on her face because she's heard the following lecture before, but I'm going to give it for your benefit.
Thank you, Judge.
ever since we had the jury reform movement and we provide more context to jurors, they better understand why we're asking what we're asking in voir dire. But they also misinterpret half of the time. When you ask questions in voir dire in a vacuum, jurors are frustrated. However, when you ask questions in voir dire after you've given a detailed opening statement about what the case is about,
I was thinking that.
some jurors misinterpret the question. And I want to use a provocative example so that you get my point. When I used to do Mr. Stafford's job, I did death penalty cases back in the days when Colorado had the death penalty. I had a case where my client was alleged to have gone hiking with his girlfriend, experienced a psychotic episode, pulled out a hunting knife, and carved a fetus out of her pregnant belly, and she died. Let's imagine that in that voir dire, you're wanting to ask about the right to remain silent. Defense counsel, who's looking to shoot out the panel, could combine the most emotional facts with the case, given in a mini opening statement, to a valid question in voir dire, such as burden of proof or right to remain silent. And imagine what it's like for that layperson when they get asked a question like this. Can you really implement the right to remain silent in a case where someone is alleged to have pulled out a hunting knife and carved a fetus out of a young woman's belly and left her body for dead on the trail? Every juror I know goes, no. And they have, the juror starts to interpret that question as, can you indicate to us what your likely verdict is going to be on a case like this? In that moment, they're experiencing the emotion of hearing very graphic facts, and they're losing sight of, we're simply asking about whether you can follow the law on burden of proof. So I have a habit, if we have given much factual detail to our jury panel, I have a habit of warning attorneys that if I think the juror is misperceiving your question and is saying something like, no, I can't do that, because I can tell they're focused on, as Mr. Stafford just referenced, the last time we tried to try this case, everyone was thinking that the accused, Ms. Onstead, is the one who had shot somebody when she's the one who got shot. And as soon as counsel quickly cleared that up in voir dire, the mood of the entire room changed. We could have saved a lot of time on that voir dire if we'd just started at the beginning with an simple explanation of who shot whom. So I'm a big believer in giving some contextual information, but I just want you to be aware of a dark side to doing that, which is you may hear me interrupt your voir dire with the following. No poll taking, counselor. You may have not done anything wrong other than misread how that juror is answering your question. There's ambiguity there. Can you be fair? Can you implement the burden of proof? Can you respect the right to remain silent in a case where a woman pulls a gun on a law enforcement officer and threatens their life? Now, when they say no, it's ambiguous about which part of that question they're answering. Is it the pulling a gun on a law enforcement officer? I get the impression 90% of the time that's what they're answering, and that they're not answering your question about burden of proof or right to remain silent. So don't be surprised if I'm reading how they're answering you differently than what you intended to have answered, if we give a lot of factual detail in a mini opening statement or in a statement of the case. There, I'll get off my soapbox.
No.
So is that making sense?
Yeah, absolutely.
I think we would all agree that the one thing you're never allowed to do in voir dire is to say, Mrs. Johnson, here are the facts of the case. Can you tell me what your likely future verdict is going to be? That's poll taking. So that's why I use the case law is clear. You can't poll take. And there's a heightened danger of that when we give too many facts of the case. So what I'm going to do is, Ms. Wertz, if you could print out the September 22nd rule.
I don't know if you guys all remember. You probably don't. She was in front of him once before, and she thought she knew the law that she was trying to argue down pat. And this judge annihilates her. Everything that she was arguing. Every time I see her, I feel bad for that day because she was embarrassed. She was. But I just thought that was, look, it was only 12 minutes of your life wasted. And Bill, you're a liar. You're a big fat liar. You didn't see this before, and that was not old. I mean, I got stuff in my refrigerator older than this hearing right here. I don't know what to do next. Let's do competency loud. I don't know what that means, so we're gonna wait. I have to make sure it's not like an hour long. Okay.
All right, good afternoon. Is this Ms. Morris?
Yes.
All right, this is 25T140.
I like this, Judge.
We were set previously. I have a motion pending from the defense, also going forward with that advisement.
Yes, Your Honor, I believe that it is necessary in this case.
All right, and Ms. Morris, your attorney has filed a motion for the court to order a competency evaluation. You are aware of that?
Yeah, we're disputing on it because here's the thing is I do have a couple of diagnoses, and my diagnosis is even as recent as of May of 2025. I have an updated psych eval and everything. And my diagnosis, I'm diagnosed with like oppositional defiance disorder. I know it is an odd one to carry when I'm an adult, right? And it's quite severe. The other thing that I struggle with is audio and visual. Like, you know, I don't comprehend like you might or like she might. And I am a survivor of many things, especially that human trafficking. I feel that because I'm asking for a certain approach in my defense instead of helping me with that, it's problematic. We don't do that. It's certain things where I'm like, but that would be part of my fair trial. And it's not that I'm incompetent by any means. I legally represent myself in the state of Utah for a juvenile case, and I've been doing it for 2.5 years, and I'm quite good at it. I grew up in 88 foster homes, 17 lockdowns, and the court system is not new to me. What is new is Colorado law, specifically knowing what my rights are and then not being able to ask without it being problems.
Okay, hang on just a second, okay? Because competency means a lot of different things. And competency means you don't have the ability to work with your attorney, and there may be some reason for that. And that may be some way to overcome that. It's not saying, you know, we want to lock you up and throw away the key or that you have these huge psychiatric problems. It's an ability to work with your attorney through your defense. And sometimes, and I was a defense attorney for 19 years, okay? And so sometimes clients ask attorneys to do things that are not legally possible. And it can be really hard when a person is saying, but this is the reality and this is what's happening, and I want you to present that. And it may not be something that legally can be presented in the court. So all your attorney is asking is that I get an evaluation done to see if this difficulty in working with your attorney is something that we can overcome. That's all. Okay. It's not a personal slam on you. It's not a dig at where you're coming from mental health wise. It's to get this evaluation done to see if there's something that can be overcome to be able to allow you and your attorney to work forward and move forward in a positive direction in this case. It may be just a matter of some levels of education with how the system works and how that moves forward in a way that maybe your attorney can't provide to you given what's going on with you. Does that make sense? Okay, so it's not a dig on you. It's not a slam on you. It's nothing negative. It's just that competency means you may not have the ability at this point in time, given everything that's going on, to assist your attorney in your defense. You may want something that can't happen, and going through this competency evaluation may help figure out what's going on and how to work through that, okay?
I understand. I just also feel that this has taken a lot of time. These type of tests that would be ordered takes time too. I have 2 children in a different state that I gotta go get. I'm against the system of Utah, and I am on time. I've kind of paused over the last year because I need to travel outside of the state.
And I understand that. And I've been dealing with your case for quite a period of time. And I know that there was an issue where there was a proposed plea agreement, and then there was the talk of a prior, and the court couldn't accept that plea agreement. So things got delayed in that nature. And the other issue is if I put you on, if you are convicted of this and I put you on supervised probation, how's that look with you traveling and what you need to do? So there are a lot of factors that have been balanced out in your case that your attorney has tried to balance, and the decision was made set.
Know the consequences, Mal. That's how educated I am of this.
Okay. Well,
my lawyer hasn't explained to me, other than the cop is impeachable because he's known to lie on a stand. There would be no jail time. Well, other than that, I do not know anything else.
Hang on. I don't know anything. I don't know the facts of your case, okay? And I don't want you to be discussing the facts of your case. But you're facing driving under the influence, and that carries with it the potential penalty of up to a year in jail. And so
we discussed this with your plea. I know that was a long time ago. We can rediscuss it.
You told me that the jail would be suspended and that there would be no.
Okay, I'm not going to get into the back and forth of the discussions you've had with your attorney, because I know that a plea was contemplated, and then the alcohol evaluation was done, and with what came back on the alcohol evaluation, which you self-reported, the court was not willing to take that. And so if there's truly a prior, this is not a non-jailable offense, and the sentence is up to me. If you go to trial and you get convicted, the sentence is up to me, okay? It is not something you bargain.
That right there just takes everything, because I'm not even, no, that was not, and that's
I
not.
believe, I believe our issue was the mandatory jail time with.
And I do have.
But we can rediscuss this.
Advocates who have sat, who can back. You never informed them.
Okay, I apologize if for some reason I didn't.
Okay, we're not having this discussion now because I have a motion filed by an officer of the court who's asking me to order a competency evaluation.
I feel like I might need to have some time to look outside for a expert DUI.
Ma'am, hang on. When this motion is filed in the court has to give you this advisement, and the court has to order the competency evaluation. I have an officer of the court who's filed a motion, who has laid out issues that present itself that there may be a competency issue, and the court now is going to give you an advisement, and I'm going to order the competency evaluation, okay?
What happens if I need new defense? And
I cannot remove your counsel while a competency is pending. Everything is
the right to look at it for good, because of my human trafficking, because she wasn't honest about how this is going, because I've had limited assistance in my defense and case, I do feel like I have the right to a second opinion to look and navigate. And I need to talk with one of my victims advocates.
okay.
Because this is.
Okay, I need you to listen to what I'm saying. This motion has been filed. I now have to give you.
Locks me into her?
No, listen to what I'm saying. I cannot make any changes in your case. If after this competency evaluation, you come back competent and you want a conflict hearing with this counsel, we will hold a conflict hearing. But because competency has been raised, everything is stayed, and I cannot make any changes in the case, I will give you the advisement that I'm going to give you. We'll get the evaluation done. Everything is stayed, meaning everything is put on hold. We'll get that evaluation done. And then when that comes back, if you want to have a conflict hearing with Ms. Sithopoulos, we will have that. If the court deems there's a
even comfortable working.
Listen to what I'm saying.
No, this is huge.
Ma'am, listen to what I'm saying. I'm going to get this evaluation done. You can speak to anybody else you want during the evaluation time, but I can't make any changes.
me my disability rights. for
Ma'am?
No reason.
Ma'am, listen to what I'm saying. I'm giving you this.
She didn't do her job.
Okay, I cannot make any changes on your case with this motion pending, okay?
Essentially without me saying so.
She doesn't have to have you say so.
She met with my advocates. This was all sideline.
Ma'am, I'm gonna give you an advisement, okay? I'd let you,
I can't. I need to have someone here other, because now I feel like, and it's again, part of my disability, I feel that I've been misinformed, a little bit lied to, and I do not know Colorado law.
okay?
I've been trying to figure it out, but I've never gone through anything like this in Colorado, ever.
Listen to what I'm saying. I'm going to give you an advisement. I'm then going to order that a doctor from the state hospital make an appointment with you to do these evaluations.
I don't want to do anything with state hospital people.
Ma'am,
I feel like that's an invasion.
I'm not sending you to the state hospital. Listen, okay, I want you to take a time. I want you to take a timeout and listen to what I'm saying. I'm going to advise you. I'm going to order this be done. It's going to be done on an outpatient basis. And let me just tell you, if I can't get this done on an outpatient basis, we'll figure out another way to do it, okay? And I'm advising.
Like, and trying to re-victimize me even.
Ma'am.
And I'm sorry, I'm difficult, but
I'm
this was an unfair motion for her to file, because I told her if this was the route she wanted to go, she needed to talk with me and my advocate so I could go the next route. And she did.
Once it's filed, I have to act on it, okay? That's what Colorado law says. So the issue of your competency to proceed has been raised, okay? At this time, the court I don't have enough information, and so I'm going to order an evaluation to determine your competency. I'm ordering that you undergo an evaluation regarding your competency to proceed, and I'm going to advise you of your rights under CRS 16-8.5-109.
Please, because I'm gonna look into these things. I do feel like
CRS.
Right.
Ma'am, I need you to listen, all right? Because I'm telling you about your rights. These are very important.
I need it written. See, not part of I need it papered and vocal, because I can't process the way you're telling me.
Okay, I will read it to you and we'll make a copy of what I'm reading to you, okay? It's 16-8.5-109. You do have an attorney appointed and you've conferred with your attorney. I understand you're in disagreement with your attorney. You're going to undergo an examination concerning your competency to proceed, and this will take place on an outpatient basis. You will be examined by one or more psychiatrists or psychologists. You shall cooperate with the competency evaluator and with other personnel providing services. Statements you make during the evaluation shall be protected as provided by the statute. Statements you make during the examination cannot be used against you during the prosecution's case in chief, but can be used as rebuttal or impeachment or during sentencing. You have the right not to say anything to the psychiatrist or the psychologist, and if you choose not to cooperate with the competency evaluator and other personnel, and that lack of cooperation is not the result of a developmental disability or mental disability, the fact of your non-cooperation may be admissible in your competency or restoration hearing or to rebut any evidence you introduce about your competency. Further, if you're non-cooperative with the competency evaluation, an evaluator may render an opinion of your competency based on confessions, admissions, and any other evidence, the circumstances surrounding the commission of the offense, as well as your known medical and social history. The opinion may be admissible into evidence at your competency or restoration hearing. By raising the issue of competency, any claim of confidentiality or privilege is deemed waived, and all parties will have access to the competency evaluation report, information and documents relating to competency evaluation that are created by, obtained by, reviewed by, or relied on by an evaluator. Excuse me. A written report of the evaluation will be prepared and provided to defense counsel, the district attorney, and the court. Within 7 days of that receipt, you can object to the findings and request a second evaluation. If you are found incompetent, the court will order you to undergo competency restoration, and this can take place on an outpatient or an inpatient basis. And during that time, you're entitled to a hearing as to whether your competency has been restored. At a competency hearing, you and the prosecuting attorney are entitled to be present in person and to examine any reports of the evaluation or other matters to be considered by the court as bearing on the determination of your competency to proceed. You are entitled to introduce evidence, summon witnesses, cross-examine opposing witnesses, or witnesses called by the court, and to make an opening and closing statement and arguments. The court may examine or cross-examine any witnesses called by you or the prosecuting attorney and may summon and examine witnesses on its own motion. Once your competency is restored, we will resume these criminal proceedings from the point we are today.
You're pretty much trying to declare me stupid.
Ma'am, if you listen to what I said earlier, I said this is not a determination of how smart you are or if you have any psychiatric illnesses. This is a determination because competency means you have the inability to work with your attorney. And we're trying to figure out why that is. It may be that you don't understand what your attorney is saying, and it may be that things have to be presented to you in a different way.
Really does. I have a diagnosis. She's just never asking for it.
I understand, but you've also said that you wanted to raise a defense that your attorney says she can't do. And so you may think that something is a defense to a case where it may legally not be able to do. And if you've come to an impasse at that point in time, a determination with regard to competency is the first step, okay? If you would make copies of the grant copy to give to the defendant.
I will set this out in 45 days. Physical copy, so I can get it to my people. Okay, I get it.
You can file with any lawsuit you want.
I'm setting this to April 1st. I'm setting this to April 1st at 10:30 for receiving the competency evaluation.
Right.
You will need to make sure that when the evaluator reaches out to you, and I need to make sure I have good contact information, that you make that appointment.
I have specialties and stuff that I gotta make sure. My liver is failing as we speak.
Ma'am?
That's why my health, so I need to make sure that you understand my liver is failing and I have to be seen by specialists. I do have more surgeries that's more invasive.
When the evaluator contacts you, you make every effort to make the appointments. And I'm not saying this as a threat, but we need to get this done, okay?
I want to also clarify, my background is tied to my human trafficking.
Ma'am, and I know, I've heard, you've told me this on several occasions.
That it's not re-victimizing in any way, and that you put the right order in to protect that. That I'm not re-victimized on my human trafficking, that my social and my past life before Colorado should not be relevant to the nature because my trafficking didn't end until the year of 2024 and I still live in involuntary servitude.
Ma'am, these doctors are professionals. They are trained in psychiatric health. I'm sure that they are going to need to know some of your background so that they can interview you and do the appropriate testing to determine your level of competency, okay?
Can I submit my current, because my sure the
doctor who's going to do this is going to want to see the evaluation you have. That's going to be critical, okay? And they will take that into account, all right? So I've set this to April 1st. I've set this to April 1st at 10:30. When the evaluator reaches out to you to make an appointment, I expect you to meet that appointment, okay?
Okay, I'll do it, but I'm not understanding everything, Your Honor. I don't understand why you want to invade my privacy into my trauma.
I do not want to invade your privacy. I want to get to the bottom of being able to work with an attorney to get your case resolved.
I have oppositional defiancy disorder.
I understand.
And a the impairment.
If there's a way that that the doctors come up with a plan, that's the way to work around that so that you can work with your attorney. The DA is not dismissing the case, okay?
I understand, but I need that understood, as I do have a very up-to-date evaluation that was completed through a court order with these diagnoses, with a psych eval right here in Colorado Springs within less than a year.
Okay.
And so if I could submit that to make it so time's not wasting, I literally need to ensure that I can get where I need to go.
Time is not wasting. We can't move this case forward without getting this done. Everything is stayed at this point in time, okay? The evaluation you have done was very different than a competency evaluation, okay? And so the doctor and the doctor you're going to meet with is going to want to know your history, mental health history. Okay.
Then it needs to be a psych eval with a special trauma. And I do know this is my right. I have the right to ask for a trauma-informed specialist of human trafficking. It's like a forensic specialist who specializes in that degree. Because that's where my trauma is. And if they're not educated in my trauma, I can have COVA, Lotus Foundation, and PESA.
Ma'am, I've ordered the evaluation. We'll let the state hospital know. They'll assign a doctor and we'll move on from there.
I just want to make sure with HIPAA, it's specialized.
I don't pick the doctor, okay? The state hospital picks the doctor. I'm ordering the evaluation. I'm going to present your history And if the doctor feels that, if that doctor feels that maybe you are not the right person, he or she is not the right person to do the evaluation, they will find someone who is.
Okay, and they will reach out to me for information before scheduling, and I will inform them that is.
Yeah, and it has to be, because that's, again, it's all paper trail.
I'll see you back on April 1st at 10:30, okay?
Yeah.
Thank you.
Yeah.
No, but being married to her would be excellent. Minimum effort required. Every 3 or 4 minutes, you just have to say, and she'll just, like, you never have to provide conversation, ever. You just, every day, it's all taken care of for you. You don't have to talk. That's the best possible marriage I can think of, where I don't have to talk at all. I can just say, and no one gets offended by me not talking. Why aren't you talking to me today? Judge, whatever you're drinking right now, I hope it's rum or vodka. I hope it's vodka, because vodka doesn't have the smell. Like, you can drink more vodka around other people and they won't know you're drinking. Not that I know this, just heard. I heard this from some myth. It is a myth. If you're drinking, people are going to know. But you should always take my advice, because it's 100% accurate and true. Medical, legal, just listen to me. You'll go places. Okay, guys. Thank you so much for coming out today. I appreciate it. I really do. True. But I have cats. So I can't have inflatable things in my house at all. Thanks, V. Yum. All right, guys. What is today? Saturday. Go and be good. Don't go to jail today. There's no judges. Wait till Monday, okay? Behave. I'll talk to you again real soon. Thank you. I appreciate it. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them. and see